This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why it is necessary to plead fraud with specificity, identifying each act of fraud when you file a qui tam action on behalf of the state. Suspicion of fraud cannot support a qui tam action. So never blow the whistle and file a qui tam action until you can specify the frauds that you are alleging in detail. Richard Campfield, suing for the state of California, appealed the trial court's sustaining of a demurrer of defendants, Safelite Group, Inc., and its subsidiaries, without leave to amend. Campfield contended he adequately alleged a cause of action under the Insurance Frauds Prevention Act, the IFPA, within the statute of limitations. In State of California ex rel. Richard Campfield versus Safelite Group, a March 29, 2024 decision of the California Court of Appeals, the court explained the requirements to plead a proper qui tam action under the IFPA. Campfield owns a windshield repair company that licenses and sells products for repairing vehicle windshield cracks. Safelite is the nation's largest retailer of vehicle glass repair and replacement services. Safelite also serves as the third-party administrator for over 175 insurance and fleet companies, including 23 of the top 30 insurers in California and the country, for processing and adjusting policyholders' vehicle glass damage claims, and it has direct electronic access to over 20 insurance company databases. In 2015, Campfield sued Safelite in federal district court in Ohio, alleging Safelite's continued reliance on its 6-inch rule that he claimed violated the Lanham's Act. Safelite admitted in responses to interrogatories in the Ohio action that it never conducted studies on the safety or viability of repair of cracks larger or longer than 6 inches. Campfield filed under seal the complaint in the present qui tam action against Safelite, alleging a single qui tam cause of action for violation of the IFPA. The insurance commissioner and the San Francisco County District Attorney declined to intervene, so in September of 2022, the trial court unsealed the complaint. Safelite demurred, arguing, among other things, that the complaint failed to allege facts constituting a cause of action under the IFPA. Campfield failed to plead his claim with sufficient particularity, and the statute of limitations barred the complaint. After briefing and a hearing, the trial court sustained the demurrer without leave to amend, based on the statute of limitations, and noted that Safelite had raised substantial arguments that the complaint had not stated a cognizable claim, and that the action was barred by the IFPA's public disclosure bar. The trial court then dismissed the action. The IFPA, the Court of Appeal noted, was enacted to prevent automobile and workers' compensation insurance fraud in order to, among other things, significantly reduce the incidence of security in automobile insurance claim payments and therefore produce a commensurate reduction in automobile insurance premiums. The sole cause of action in the complaint is based on Insurance Code Section 1871.7, Subdivision B, which allows for the imposition of civil penalties and other remedies against anyone who violates Insurance Code Section 1871.7 or Penal Code Sections 549, 550, or 551. Campfield alleges Safelite violated Penal Code Section 550 subdivision B1 and 2. As in any action sounding in fraud, an IFPA action must be pleaded with particularity. Analyzing the issue before it, the Court of Appeal noted that to effectively state an IFPA cause of action, Campfield must allege facts showing that Safelight presented or caused to be presented a false statement as part of or in support or opposition to a claim for payment or other benefit pursuant to an insurance policy, or prepared or made a false statement intended to be presented to any insurer or any insurance claimant in connection with or in support of or opposition to any claim, payment, or other benefit pursuant to an insurance policy. Campfield alleged Safelight violated these provisions when it prepared and presented false statements to insurance companies, either as insurers' third-party administrators or as windshield repair and replacement services. The pleading standard Campfield must meet is not onerous. Campfield must only identify every fraudulent claim he alleges has been presented. As a result, Safelight did not have, because he alleged none, allegations to defend against. The failure of allegations of specific fraudulent claims left Safelight with the need to guess what it was being charged with. A lack of discovery excuse by Campfield and his failure to plead his IFPA claims with sufficient detail defeated his suit. The heightened pleading standard exists in part to deter the filing of complaints as a pretext for the discovery of unknown wrongs and to prohibit plaintiffs from unilaterally imposing upon the court, the parties, and society enormous social and economic costs absent some factual basis. Qui tam actions like Campfield's under the IFPA are meant to encourage private whistleblowers uniquely armed with information about false claims to come forward. These insiders should have adequate knowledge of the fraudulent acts to comply with the heightened pleading requirement. The IFPA is not intended to provide a mechanism for those with general suspicions of wrongdoing like Campfield to engage in discovery seeking to confirm their suspicions. In my opinion, the qui tam provision of the IFPA is a wonderful tool to be used in the battle against insurance fraud. It has acted as a way to defeat fraud that local prosecutors are unwilling to prosecute. Rather than putting fraudsters in prison, the qui tam provision allows the relator and the state to take the profit out of the crime. However, as this case establishes, it is not a place to shop for evidence when a person only suspects but has no specific acts of fraud. Insurers should file qui tam actions if they have evidence, and if they don't, they should not. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will be advised of every blog posting, usually 5 or 6 a week, and you'll have access to the more than 4,750 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.